Okay, good morning, Council. I'll ask the clerk to call the first case.
SJC-12974, Town of Brookline v. Gerald, Alston.
Great. Mr. Podolsky, you're first.
Thank you, Your Honor. May it please the court, Joseph Podolsky for the Town of Brookline. This court solicited amicus briefs on a very specific issue, and that was whether the Superior Court judge properly ruled that the town lacked just cause to terminate a firefighter for unfitness where the termination would not have occurred but for the town's racially hostile work environment, maintained in violation of basic merit principles as defined in Chapter 31, Section 1. The original unanimous conclusion of the Civil Service Commission when it first heard this case was that the town's decision was in compliance with Chapter 31. Fully aware of Mr. Alston's arguments as to his unfitness and his argument that his unfitness was the result of race discrimination. This goes to many of the issues raised in the papers: precedent, statutory interpretation, deference. The commission cites a long line of decisions regarding the ability of an appointing authority to terminate an unfit employee regardless of the cause. Commission specifically states under civil service law, the decision does not turn on whether or not the cause of the disability is attributable to the employer, the employee, or a third party.
Counsel, can I interrupt you there and just because we're familiar with the facts of your case and the law on this and all the various permutations this case has gone through. You know, it's taken a while. So I'd like to change the focus a little bit with a hypothetical, and to take it out of this realm that you're in, so that it's not, so that you don't have to admit to anything or argue anything you don't want to argue. And that is, let's take a female plaintiff, a female employee, who maybe throughout the course of her life has been subject to catcalls, maybe some sexual assault. It's a high number of women who have endured that throughout their lives. And she enters a profession, maybe one where there are a lot of men, perhaps feeling, she's grown up now, they're grown up, this won't happen. And she's sexually harassed. And it really affects her. And she complains about it. And as a result of that complaint, the men double down. And she's ostracized, she's marginalized, she's made fun of. And so going into work becomes quite traumatic and affects her mental health. Would you still say in that case, she's not been affected by, that it wasn't the employment environment, the hostile work environment that caused her to be unfit for the job?
So in your hypothetical, Your Honor, I think that that's something that actually is addressed by a civil service case on record, and that's the Dalrymple case. Miss Dalrymple was a Winthrop police officer, recently retired. She had a long history of discrimination within the department, hostile work environment claims. And in the course of her tenure, 40-year tenure with the department, she had many issues. She actually received many verdicts from a jury from the MCAD finding in her favor. Separately, she had a civil service, a number of civil service issues, and those civil service issues were addressed by the commission under civil service law. And so I think your question has different answers depending upon the forum in which the case is litigated. And the phrase employment environment under civil service law, I think, means something different than employment environment under Chapter 151B, and I think the cases speak to that.
What's the difference?
Well, under 151B, there's a hostile work environment standard. That standard is specifically within 151B and the case law that derives from 151B. That standard is tested. It's been up through the courts at all levels. There's very specific guides to employees, employers, as to what is and is not discrimination. There's very specific guides as to what an employer's responsibility is when that employer is on notice.
Okay, and so what's the civil service definition?
Under civil service, there's no specific environment standard. And that, I think, is one of the issues with this case. So the case that I cite, that many of the parties cite in this matter, is Vennard versus the town of Canton. That case also involved a female firefighter with gender discrimination claims. And
Were they gender or sex, counsel? Sometimes they distinguish.
I believe there were gender discrimination claims. The employee in that case brought an appeal to the Civil Service Commission and said that these actions were taken against me because of gender discrimination. And the commission stated in the decision that the claims may have merit, but that's for the MCAD, and if removed, the courts to decide her 151B suit. That's actually the case in which the dicta phrase from the commission, the phrase from the commission comes from dicta, quote, "The commission has concurrent authority to address such matters as violation of basic merit principles of civil service law." Interestingly, in that case, the commission doesn't actually address the environment under the basic merit principles. Rather, it defers to the MCAD on a hostile work environment claim.
Right.
The commission.
What about causation? Does it address that?
Causation for the
For
hostile.
the alleged unfitness?
In that case, no, it doesn't. There are other cases cited by the commission in the string cites in the briefs, which specifically state what I stated earlier, which is that when it comes to fitness evaluations under civil service law, causation is not part of the standard.
Okay, so then now let's move to the facts of your case. So is it your major argument then that notwithstanding any facts, the basic problem is there's an exclusivity issue with 151B, and the Civil Service Commission is just not the right place for that challenge?
That's one of the major arguments. Yes, Your Honor. And part of that is in that Vennard case, the Civil Service Commission cites Phillips versus Cambridge, Holden versus the DOC. And in citing that specifically says fairly classic employment discrimination claims are not something that the Civil Service Commission does. That's something that should take place at the MCAD. The very same year, the commission issued a decision in Pereira de Araujo versus the Abington Police Department, 31 MCSR 59. And the commission very specifically states, quote, "The commission has no jurisdiction over discrimination." It was not.
Counsel, can I interrupt you for a second?
Yes, Your Honor.
The failure of having jurisdiction over a discrimination claim is one thing, but the commission does have the ability to determine whether or not the termination was for just cause. And I guess I'm struggling with the argument that in evaluating just cause, the commission cannot, which I think is your position, cannot consider whether or not the person was terminated because of their inability to conform to an environment that had become racially charged. I think that at the bottom, that is your position, that the commission cannot consider whether just cause includes the ability of the employee to conform his conduct to a racially charged environment.
That is not quite the position of the town. The town, Mr. Alston filed a discrimination claim in federal court, which the town defended on discrimination law, and Judge O'Toole dismissed the case at the summary judgment stage. And so the town—
Right, well, that was for failure to prosecute. There was never a finding of no discrimination or discrimination, was there?
No, Your Honor, that case was on the merits, substantively on the merits, involving the federal court discovery record, which was a 2.5-3 year discovery record, and the record of the testimony and the exhibits, documentary exhibits before the Civil Service Commission. The case that Your Honor is referring to is the Norfolk Superior Court case.
You're right.
And that case was specifically involving Mr. Alston's discrimination claims, both for the 2010 incident and his claim of a hostile work environment. And the commission found that that case was dismissed for procedural reasons. And that is not, that's not in accordance with the actual reason for dismissal, and it's not in accordance with the case law. That case was dismissed in Norfolk. It was a charge filed in 2012 at the MCAD, removed to Norfolk Superior Court. That case was.
Can I interrupt you? I just getting back to my question though, in connection with determining just cause, what legal authority or proposition would preclude the commission from considering whether or not the employee failed to conform his conduct to a racially charged environment?
So assuming for the sake of answering your question that the premise of the question that there was a hostile work environment, the case law cited by the commission, one of which I spoke to already, Vennard versus the town of Canton, Marcus versus the city of Chelsea, Morgan versus the town of Billerica, Pooza versus Westfield Police Department, all within the commission's April 2017 decision, specifically say that the cause of the disabling injury or the cause of the unfitness is not something that the commission gets into in determining whether or not someone's unfit. And the other issue is the issue of the order.
That can't be right. I mean, if the employer, if the employer beats the employee up, and he can't do the job, he can't be returned to work. They can just fire him.
It's not to say, Your Honor, that the employee wouldn't have remedies to remedy.
The employee has civil service remedies. You can't. The only way you can fire someone under the civil service laws, it has to be for just cause. And basic merit principles explicitly adopt the idea that discrimination on the basis of race is not just cause. That part I don't have any trouble with. The part I have real problem with is the remedies here are so complicated, because the remedies for discrimination under 151B are very subtle and varied. You can have constructive discharge, you can get front pay, you can get back pay. Here we're stuck with this very limited remedy of return to work. Isn't that the problem? I just think you have a loser if you're going to argue that discrimination is completely out of bounds in the civil service context. That just seems wrong, but I see the remedy being too rigid to deal with the problems we have, which is the employee now may not be able to be a firefighter and he's been returned to work. So assume you're wrong for a second, that race discrimination is not the basis, that if race is properly considered. But I don't know how to deal with the remedy because the remedy seems too rigid. Can you address that? Again, assuming I know you're reserving your rights. You think race, they can discriminate on the basis of race and it won't be a just cause discharge. But say we disagree with you on that. But I'm concerned that the remedy here doesn't deal with the fact that someone can both be discriminated against and unable to do the job, and seems to require them to be put back to work.
I think that's what civil service law does require, Your Honor, under Section 43. It's reinstatement to the job that person was terminated from. And I think that part of the issue here is that there are laws in effect under 151B, under Chapter 32, under Chapter 41, Section 111F, that specifically deal with how a person has a remedy when they are unfit as a result of something that happened at work, That's
Let me
H1.
ask you Justice Gaffer's question a different way, Mr. Podolsky. Let's say that the relief from judgment motion had been allowed in Norfolk Superior Court. Let's say, and I know you disagree with this, all the evidence came in consistent with what Mr. Alston is alleging. What would be the remedy?
Well, that would be a 151B claim. So the court would have plenary authority. They have injunctive relief. They could issue an equitable order. They could issue.
Well, I know, but I want to be sort of tactile here with Justice Gaffer's question. What we have here is, again, on Mr. Alston's facts, a hostile work environment. It's created by the fire department, not by the firefighter. He just can't go back there. And yet we've got concerns, even if he were reinstated, that he wouldn't be able to go back because of some other concerns. What's the remedy look like?
He could receive a compensatory award. There could be a punitive award. I don't think that remedy.
But that's only under 151B. I'm trying to, just to circle back to my question is, what do we do? How does the remedy, I think Justice Lowe is asking the same question, but what would be the remedy in the civil service context?
Exactly.
And we got two different prongs. We have one at where, like Norfolk, they dismissed it, but not on the merits. Say we again disagree with you on that. But at the same time, we have discrimination based on race here. What's the remedy in civil service? Is your argument, because the civil service remedy is only that you return to work, that can't be a remedy because he can't do the job? Is that your argument? Because there has to be some remedy if there's a wrong, isn't there?
My position is that highlights why Civil Service Commission is not the jurisdiction with jurisdiction over matters such as this, because they do not have a legislatively prescribed remedy for the scenario that your honors have described. It's not something that the legislature has ever envisioned. It's not something that has ever occurred in civil service law.
Well, you say the legislature has never envisioned it, but Chapter 31, Section 1 says, as far as basic merit principles go, assuring fair treatment of all applicants and employees in all aspects of personal administration without regard to race or color. Doesn't that demonstrate a legislative intent?
That specifically states that in administering the Commonwealth Civil Service Law, those factors should not be used. And this court's cases speak to that, the Mamleo case most directly. That it says very directly that in administering that law, you cannot use any of the enumerated protected classes, including race. And
there's just no way we have said that. I mean, not in this context. The remedy is exclusive if the case is pending or there's a final determination on the merits. So we don't have that here. I know you're arguing that it's a decision on the merits, but it's a discovery violation. So we don't have a decision on the merits. It's not exclusive, but we got a remedy that doesn't make any sense in the civil service context if the person can't do the job. So I don't know where that leaves us, but it leaves us with great uncertainty, not clarity here. You know, you're kind of making it simple, but you know, it's just not. And it just seems, I mean, I understand because 151B, the cases weren't properly prosecuted. We don't have any guidance on this side, but we're sort of stuck with a remedy, with a wrong without the right remedy.
I suggest we turn to Counselor Ames and Quinnen and see what they have to say about this. um,
you.
Attorney Ames.
Thank you, Your Honor.
You unmute, sir?
Thank you, Your Honors. Brooks Ames representing Gerald Alston. I will take up the court's question about remedy. It seems to me that Judge Wilkins got this right when he said if the statute, the civil service statute provides that if the municipality fails to show just cause for termination, the remedy is reinstatement. And that does not create an injustice.
Well, but how does it, can I push you then on this? So I agree that racial discrimination is a relevant factor under the civil service laws. I don't have a problem with that part of your argument. But your client doesn't comply with any of the process, the drug testing, the appearing for meetings with the chiefs. They can't be assured, and he's got a very dangerous and important job. If they can't figure out whether he can do the job, this rigid reinstatement remedy potentially exposes him, his fellow fighter fighters, and the public to danger, doesn't it? I mean, just because and under 151B, there'd be lots of solutions. He could get a constructive discharge. He could get front pay. He'd have a duty to mitigate his damages. I mean, it makes a lot of sense under 151B, but this remedy in this context is very limited. I'm just trying to figure out how we accomplish all the goals we have to address here.
Well, if the reason that he's unable to return to work is the discrimination, then that's the heart of it. Now, I take your point that if he can't return to work for whatever reason, if he's not capable of doing the job for whatever reason, then there's not a good reason that he actually be performing the duties of a firefighter on the job. But that's not required. He's currently on the payroll. He's a firefighter in good standing. He's just on leave with pay. And there are remedies.
Forever?
There are remedies for the
forever? I'm just trying to get a sense of, does the town have the ability, say we agree with you that the town has handled him improperly and in a discriminatory way, but now they've gotten their act together and they have to make sure he can, one, do the work, and that, you know, they can't pay someone to do nothing, can they? So what are their options?
I think that the commission's brief, and I'm sorry to steal my brother's thunder here, but the commission's brief sets out one statute that is available to an employer in the town of Brookline's position here. And that statute is the involuntary accidental disability retirement statute, which says that if you have an employee who's been disabled essentially in the line of duty, you can retire them, even if they don't want to retire. There's a remedy. It's involuntary retirement. So if the town takes the position, which I believe the town does, which is that Mr. Alston is incapacitated from performing his duties, it's not without recourse in terms of, you know, what it can do. It could choose to involuntarily retire him and ask the state board, retirement board, to put him on an accidental disability retirement. That is something that's available to the town. It hasn't chosen to do that, but that is available to it. I'll keep going, but that's the chief.
And that won't be a violation of the civil service laws. If they discriminated against him. It led to his disability. He now can't do the work, but they can do that without violating this, because the civil services ordered him reinstated. But you're saying that they can do that, and that won't be a subsequent violation of either 151B or the civil service laws? Is that what you're saying?
Yes, I don't think that would be. I see those as complementary statutes in some respect. Now, the other possibility, Your Honors, is that once the cloud of this case is removed from Mr. Alston, because this has created a reputational harm to Mr. Alston. He has been branded essentially an unfit firefighter by the town, not based on, according to the town, not based on its misconduct, but according to the town, based on Mr. Alston's misconduct. Once that cloud has been removed, Mr. Alston could potentially try to seek a firefighter position in another jurisdiction. That's a possibility, but there would have to be a name clearing, which really only the end of this process can provide.
How would that work if he was, this may not have anything to do with this particular case, but how would that work if he's been involuntarily retired on accidental disability? How could he?
Well, those are alternative possibilities that could come out of Mr. Alston being reinstated. The town could exercise its right to try to involuntarily retire him, or something could be worked out in which he attempts to work at another department. But
Counsel, is there another remedy possible that once this issue would be ordered, once this order would be issued, that the town or the fire department could work out some kind of settlement agreement with Mr. Alston?
Yes, that's clearly another remedy that the town could choose to buy him out, for instance. That's a possibility. The other possibility is that Your Honors could suggest that the legislature amend the statute to provide a particular remedy in this circumstances. If your view is that the current remedy is too rigid, that's another possibility. The legislature has the power to change the remedy if it doesn't view this as flexible enough.
There's a federal case, from what I understand, the federal case is on appeal. Is that correct?
Yes, Mr. Podolsky and I argued that to the First Circuit on Tuesday. And
if they reverse the decision of the federal district court, meaning that there's a wide discrimination case involved, does that affect if that had been the state court, that would mean that we'd have a pending 151B case. If we have a pending federal discrimination case, does that affect what we can do, or is that totally separate?
I believe that that's entirely separate. I do want to push back on my brother's argument that there's something significant about the fact that the district court entered summary judgment. On appeal, the argument that we made was that the summary judgment was entered in error because the judge chose not to take into account on the summary judgment record the facts that have been found by the commission. So we don't think it's a useful, the federal case isn't a useful guide for the question that's in front of Your Honors.
How would the federal court have to defer to the Civil Service Commission's fact-finding?
It doesn't have to defer to the commission's fact-finding, but with regards to summary judgment, it has to view the facts in the light most favorable to Mr. Alston. And the Civil Service Commission's report is a presentation of facts that, if credited by a jury, could support the claims that Mr. Alston is making in federal court.
And there was no appeal of the Norfolk judgment, so there was a motion for a new trial. I can't remember what they filed in that case, but that case is dead. The state 151B case is over and done with, and there's no pending appeal on that, right?
Correct. And importantly, that case concluded in 2014. So it clearly did not address the question of whether Mr. Alston was correctly terminated in 2016. There was a fair amount that occurred between 2014 and 2016. And Judge Wilkins correctly stated in his opinion that the claimant isn't required to rely on the last straw, just the last straw when they're alleging a hostile work environment has caused their inability to return to work.
Chief, could I just, before we lose Mr. Ames, quick question?
Yep.
Counselor, I just like to get your take on the argument that the remand was incorrect, and that the problem here is really in a way that you've got the civil service dealing with a medical disability as a result of a hostile work environment, and that the civil service just shouldn't be and is unable to do that. Doesn't even have the means to do it. And I guess by way of example, if it's Dr. Price is, has an opinion, and it seems like the decision's in contravention of the opinion.
Well, as to the commission's jurisdiction, it seems to me that the whole purpose of the civil service law is to protect employees from bad faith terminations. And this is a classic bad faith termination because it's based on something that's completely out of Mr. Alston's control. It's a question of bias that's reflected in a hostile work environment that makes it impossible for him to work. And that goes right to the heart of what the civil service law is intended to address. And the particular amendment to that law brings into that protection explicitly the protection from racial discrimination. So it seems to me this is exactly the sort of thing that the commission should do. And I would hope that the opinion that comes out of this would encourage the commission to continue to do this, because racism in public safety workplaces is very divisive and damaging, not only to the individual employees involved, but it threatens the operation of the entire department because of the paramilitary nature of these departments, where you really have to depend on the other person and have that trust. If that trust isn't there, public safety breaks down, cooperation breaks down, it creates a hazard in the workplace. So I think this is exactly the sort of case that the commission should be taking up and adjudicating.
Any other questions? Okay. Attorney Quinnen. You're on mute.
May it now please the court. I'd like to begin by recapping, I think, the 5 options that were open to the parties in this case to resolve this matter. First and foremost, they certainly could have reached an out-of-court resolution of this matter. Secondly, as my brother mentioned, an involuntary, if necessary, disability retirement was an option in this case. Thirdly, the town—
Can I ask how that works though? So that's subject to your other clients, PIRAC or whatever, CRAB, whoever that's going to be dependent on whether they find, right? That's all. So we've got a civil service remedy that says he's got to be reinstated. And then we've got this other remedy that you're talking about that's totally dependent on other state, the other clients you represent, right? It's a bit of an oddity, isn't it, that we're going to say that the remedy here makes sense based on something we don't even know what the resolution of it will be, right?
Well, we do know in this case that there were multiple mental health treatment providers, at least 4, that unanimously agreed that Gerald Alston was suffering from a disability as a result of this hostile work environment, and that several of them agreed that he was incapable of returning to work because of the environment. So that would be the principal predicate.
If we issue an order, and again, I'm trying to how this plays out in a way that everybody's different needs and the statutory requirements are met. If we issue an order saying he was discriminated against, but he may not be able to be reinstated, even though that is a requirement of the civil service laws, but that's okay because if he can't do it, he may get accidental disability. That's an acceptable legal resolution of this case?
Well, as Your Honor pointed out, it isn't a guarantee that all the necessary parties would accept this. So the commission did what it could do and what it was obliged to do, first by considering the question posed by Justice Wentland, that the commission was obliged to consider whether, because of a work environment that had become racially charged and intolerable for this individual, he was unable to fit in.
But is that right, though? Because I'm worried that the commission has to be able to do the job to be ordered reinstated. That's what I'm worried about. Is that what I get that the Civil Service Commission could take into account race discrimination. I get that if they caused his disability by racial discrimination, they're not off the hook. But can you order someone back to work, particularly in a job like a firefighter, where there's no evidence they can do the job?
Well, what the town could not do is simply cut him loose and terminate him and say, we have no further obligations to you. That's what they did. That's what is unlawful in this case. And that is why the commission needed to intervene and order his reinstatement. Now, it leaves the town able to cure the hostile work environment potentially by ensuring that there is no interaction between Alston and those who tormented him.
Counsel, if I can interrupt, isn't that really the answer to Justice Kafker's question? That, civil service has this one remedy, reinstatement. And if the town, assuming that it's true that it had a racially charged firefighting department, wants to do something, it's its responsibility to change the environment and see if Mr. Alston can therefore work in this new environment that's not racially charged.
Absolutely. And whether that be within the Brookline Fire Department Station number 2, or within the Brookline Fire Department altogether, or whether they need to rehabilitate him to the point where he could be employed by a different community as a firefighter. Those are all other options open to the town in this circumstance.
And you had started delineating the 5 options available, and you stopped at 2. What were the other 3?
So could have cured the hostile work environment such that he could go back to the actual job. They could have, as I said, rehabilitated him to be able to transfer to a new work environment. Or the final option is what is happening. He's reinstated and he's placed on paid leave. Those are the options. Now to turn back to-
Can I ask?
Sure.
But we also have a lot of fact finding by the Civil Service Commission that he's not cooperating, that they've asked him to show up to meet with the chief and he doesn't show up. They've asked him to do drug testing and he refuses to do the drug testing.
But what comes first? I mean, isn't the first thing that needs to happen is that the town makes it possible for him to return to work by curing the racially hostile work environment? He did ask to meet with the policymaking level of the town, and he was rebuffed time and again. One meeting with the chair of the Board of Selectmen ended with the chair of the select board getting up and leaving the meeting in a huff. So, you know, the first thing is that the town needed to take steps to accommodate him, to cure the situation.
Mr. Quinn, how do we measure that? Or how does the town measure the abolition of a racially charged atmosphere? I think everybody in the world would want to know that.
Yeah.
If we could measure the elimination of racism in an institution.
Well, that is a very difficult challenge, no question about that. But certainly engaging in productive, constructive dialogue would have been a start. And we know that even that didn't happen here.
But I'm just getting to the end point, because we're left with an all or nothing remedy. And I understand what the civil law is different than the discrimination laws as well. But I just think, you know, saying that once there's a cure for racism, it's over, I just don't see that.
Well, so I think that leaves us where we're at, which is that he's been reinstated, and until the town can come to an accommodation with him, he's going to remain on paid leave.
Any other questions? Okay, thank you very much, counsel.
Thank you.